Court of Common Pleas, Union 4 Butler County, the Honorable Joe McGuffrey presiding, is now in session.
Good morning. Back on the record in State v. Madden, CR 22-121675. And Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio, and Mr. Madden appears with counsel, Mr. Wilder. The jurors are not in the room. We bring the jury in the room. Is there anything that the state would like to put on the record?
Good morning, Your Honor, and I'm pleased to thank you.
Okay, anything on behalf of the defense at this time?
Yes, Judge. This morning, we had a couple witnesses who were going to testify. One of them is Mr. Madden's brother, Tim, who's in the courtroom today. I plan to call him, but it's my understanding that my client does not want that done, so I want to put that on the record. That he does not want that to occur.
All right, very well. Anything else you'd like to put on the record today?
We also had a neighbor, Tamara Dewar. She was here Monday and Thursday. I thought she was going to be back here today to testify. She does not appear to be here at this point. However, given some of the testimony by other neighbors and the reason she was going to be called, I think we have got into evidence, so I'm not requesting that her appearance be found at this time.
All right. We will be letting the state of Ohio rest, and would you like to present a case after the state is rested?
Your Honor, with those things that I just mentioned, the only other potential witness would have been Mr. Madden himself. So I don't know if this is the time to discuss that or not, because his decision whether to testify or not. So given that he doesn't want his brother and there's no other witnesses ready and available, Mr. Madden is the only remaining one. So I think we need that colloquy now.
All right. Mr. Madden, you do have the right to testify in this trial. It is your constitutional right. Do you wish to exercise that right today?
No, ma'am.
All right, then we will let the state rest its case, and we will be prepared for closing arguments. Let's go ahead and take a seat, because I think we're going to have some other business then to take up, so we can move a little bit more smoothly through the process. Okay, so we'll be ready for closing arguments, and we talked about our jury instructions. I did see that you filed a proposed jury instruction. Mr. Wilder, I have reviewed your motion. Is there anything else you'd like to put on the record in support of your request?
No, Judge. Everything I would say right now is contained within my motion. It's filed as record, so I would stand on the motion and incorporate those arguments in the paper as if stated here this morning. So I would stand on my motion.
And does the state wish to respond to the request for the jury instruction?
So, Your Honor, voluntary manslaughter, I read as being defined as no person while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by the victim, as reasonably sufficient to incite the person into using deadly force, shall knowingly cause the death of another or the unlawful termination of another's pregnancy. Obviously, that's what doesn't apply. While I certainly will probably go find me some arguments that stabbing somebody 55 times certainly seems to be a sudden fit of rage or sudden passion, I do not believe that there's any evidence that would suggest, or any evidence that we heard from this witness stand that says that was brought on by the victim, Rochelle Bruce. Also, at this point, because that part is lacking, I would object to the instruction.
Okay, well, the court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case 2021 Ohio 1537. In that case, the trial court declined to give an instruction on voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011 Ohio 666 in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence the defendant believes was proffered that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give the voluntary manslaughter instruction, so it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over to the court proposed previously?
I think all of them are standard issued OJI instructions. I would just ask for a new copy of what it is. It's also going to be read to the jury.
Okay. Any other requests or additions, Mr. Weiler?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to you.
I do, somewhere. Your Honor, when I read through the draft, I
Yes.
think the pronouns were wrong. In
Okay,
some of the parts,
okay.
I think it said her, it should say him.
Okay. I will hopefully catch those as I
Okay.
read them and make the changes for the final copy that I'll provide to you and before it goes back to the jury.
Thank you.
And Judge, if I
Yes,
may,
sir.
I did note that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is.
Oh, because we had it in that
It
you
says
would.
if he
Yes,
does
sir.
testify, so obviously, there needs to be language about him not testifying and accept, the standard language of not
Yes, sir.
use that minutes, so.
All right. Thank you for that.
Your Honor, if I could just add one more thing. I've asked him multiple times to subpoena some information that would show how this all started, and he's refused over a period of months. He's told me to my face that he's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rochelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living. But he thought that wasn't sufficient of evidence for the jury to hear, and I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand, but listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective, this gentleman right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes, down to the bottom of the basement, inside a cell. You could hear me screaming out. Why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, when I said, hey, ask him if he knows Rochelle's niece, who works at the front desk at the Hamilton Police Department, in the same building that he works at. I just asked him if he how well he knows her. He refused to do that. So there's so many things that I thought that I just wanted to put on the record. And that's all I had to say right now.
Is there anything else, Mr. Wilder?
Judge, I'm not going to respond to the allegations, because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I am prepared to argue his case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, one other thing. You know that on March the 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45. Times that my family didn't even know that because times were being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always, and woken up out of my sleep saying, hey, you got a court date today. Having hearings without me there. But I was in the jury box and I said, hey, they were wanting to have a proceeding with me while I was inside there. And I said, I protested. I said, hey, listen, I'd like to be at the desk, so that I can go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can sure be 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sit at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, it said get him. And I had his shoes beaten off me all the way down the hallway, down 2 hallways, down to the elevator, and this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to him.
We've talked about some of this before.
Okay.
I've got your jury is waiting, and I don't want to keep them waiting, okay?
Yes, ma'am.
So if
Yes, ma'am.
if everybody's prepared to go forward, we'll go on with the closing arguments, and I'll have the jury instructions modified while we're doing that and have them passed out to you before they're read to the jurors. But we will
But
change the
I did ask
language
for
of that.
on the record, I did ask for that preservation of that footage. Of the footage when I was beat up at the jail too. So, but none of those things. Multiple. But here we are.
And we're going to go ahead and bring in the jurors. Okay, thank you. Please be seated. Good morning, ladies and gentlemen. Does anyone have any violations of the court's recess instructions to report? Okay. All right, we left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, the state has no other witnesses to present to the ladies and gentlemen of the jury, and the state will rest.
Very well. Mr. Wilder, does the defendant wish to present a case?
No, Your Honor. Thank you.
Very well. Okay, so ladies and gentlemen, you have now heard all of the witnesses, and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words in a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.
We move the...
Sure.
Thank you. That's fine.
What do you have numbers you want, because it's
Do I need to go? Push. Thank you. May I proceed?
You may.
Morning, ladies and gentlemen. Back over there. I'm going to read to you Toby Madden's own words. These are the words that he spoke on Monday before you entered the courtroom, before opening statements. I'm responsible for what happened to her. I didn't mean it. I'm so sorry. I love you. Please don't hate me. Can you put up State's Exhibit 181, please? This is what he's responsible for. You put up State's Exhibit 40. This is the it that he didn't mean to do. 55 times he didn't mean it. Let me take that down. If you recall from my opening statement on Monday morning, I told you how every trial is like a puzzle, and that you receive pieces of the puzzle throughout the week. And that's what's happened this week. And you receive those pieces of the puzzle from the exhibits that have been admitted and from the witnesses that have testified. And I want to talk about those pieces that you've received all week long. And I want to help put them together for you. So we know, and I'm not going to go in the same order that they came in, but I'm going to try and put this in chronological order for you. So we know from Michaela Madden and Tanya Cook that the defendant and Rochelle were together for about 25 years, or north of 25 years. That they moved around from place to place. Michaela said they moved around from place to place. And they finally moved to 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio, in the early of October 2022. And that they were renovating this home and fixing it up to live there. We also know from Michaela that they had a rocky and on-again, off-again relationship. And we know from Tanya that the defendant had been seen hitting Rochelle in the past, and that he said that he wanted to cut her head off and put it in her mom's lap. And he said it multiple times. I'm not sure that rocky is the right word for that relationship. We also know from Detective Horton that on October 10th of 2022, the defendant went to the Kroger on Route 4 and Grand Boulevard here in the city of Hamilton. And that was in the evening. And you saw the video and the still photos. He had on a gray shirt, short sleeve shirt, button-down shirt, a green vest, white shorts, and Nike Kevin Durant 8 shoes, or KD8s. And that was in the late evening around, I believe it was around 8 p.m. on October 10th. The next pieces that you got were from the City of Hamilton utility workers. You heard from the 4 of them, specifically the 3 that went into the house. We know that there was an appointment that they had at 8 a.m. on October 11th in the morning, that they showed up on time, that Rochelle let them in, and that she sat on the couch, had a hold of their large, big dog. I believe one of them said it looked like a pit bull. All the furniture was in its place. The china cabinet was upright. The entertainment center was upright. There weren't any chairs overturned. Nothing was overturned. And that they walked through the house and they saw a male sleeping in a chair in the adjacent room. They went into the basement. They did whatever it is they were doing, running their test on the gas line. And they determine that they can't turn on the gas because the furnace is broke or it hasn't been fixed yet. And they go back upstairs, and they're leaving at about 8:25. They see the male still in the chair. I think he acknowledges a "what's up" to one of them. They tell Rochelle that they can't hook up the gas because the furnace isn't working. And that one utility worker told you that she then looks to her right to the adjacent room and gives a stare or a look to the male in the chair. And that when they left there around 8:25 in the morning, she was alive, she was well, still had a hold of her dog, everything was fine in that house. And we know from Ann Mayers, who testified, that, as she did every day, as she said, she was on her porch at around 8:45 a.m. because she watches her sister's grandson with her sister walk to school at Crawford Woods Elementary, which is right down the street. After the grandson gets around the corner and heads up to the school and out of eyesight, her sister goes inside because she said her sister wasn't feeling well. So Ann sat out there, still drinking her coffee, looking at her phone. And she tells you that sometime between 9 a.m. and 10 a.m., roughly, she doesn't remember exactly, it was 2 years ago, that she hears a scream. You all heard it. She did it for you right here in the courtroom. And she said it lasted 5 to 7 seconds, and then it came from her left. And she's at 1260 Parrish Avenue. They're at 1270 Parrish Avenue on her left. But as she said, she doesn't know. There's a lot of kids in the neighborhood. There's a lot of screaming that goes on, but she heard this one from that direction, but she didn't do anything about it. She didn't call the police. Said she went inside and she ate breakfast. And from that time that she was out on her porch, she said there was no one else out there at 1270. She didn't see anyone. The utility workers had already left. And then the next thing we know is that Officer Katie Johnson arrives there around noon or 12:10 in response to a 911 call. She gets there. The defendant's inside giving CPR to a clearly deceased body. There's multiple stab wounds in the body. Officer Johnson saw that. She said the body was very pale and the intestines were protruding from the torso. She pulls the defendant off of Rochelle and takes him outside. At this point, he's got on a lime green shirt, shorts, and Reebok shoes. Officer Johnson told you at that time there is no signs of forced entry in that house. So when you look at the timing from when Ms. Mayers told you that she heard that scream, and by the time Officer Johnson gets there, the defendant had roughly 2 hours to be alone in that house with Rochelle. And you heard from numerous detectives about the scene and their investigation and the pieces of the puzzle that they give you. When they get there, there's no forced entry. Front door jamb is fine. The back door, it does have a dent in the door, but it's got 2 deadbolts. You saw the picture of that. That door's locked. It's secure. Rochelle's lying dead in that front room with multiple stab wounds in her body. That front room is in disarray. Furniture's overturned. You saw the cabinet on the floor right next to her. There's blood everywhere, on the walls, on the floor. It smells like rubbing alcohol, and there's 2 empty bottles of rubbing alcohol in that room near her. And then in the basement, which is completely dark, if you remember, those detectives told you, there's no electricity down there. They had to light that up themselves. They find the green vest, a bloody green vest. Turns out there's the bloody gray shirt down there, which, yes, they didn't get that until about 15 days later because of the Kroger video. But they don't find any white shorts or any Nike KD8s. There's a wooden board on the ground next to Rochelle's body with 2 distinct shoe prints on it. One of which is that Reebok shoes that he was wearing when the police got there. And the other one, as Detective Horton told you, as he found on the internet, is a shoe print of a Nike KD8. There's blood in the bathroom sink and on the bathroom floor. And keep in mind, he had roughly 2 hours from the time Ann heard that scream to when the police got there. They find a Swiss Army knife in Rochelle's bag. And it appears to be wet when Detective Horton finds it. Detective Trenham tells you when he examines it, it appears to be rinsed or washed. And it's got a deformed blade, a broken blade, that matches and is similar to the tears in the fabric in the green vest and the cuts in that Planet Fitness shirt that Rochelle was wearing. And you know from Detective Horton that the defendant told him, you got to find those 3 city guys. You got to find them. There's people out to get me, but there's not anybody that I know that wants to hurt Rochelle. And then Catherine Daly from BCI supplies you with these pieces. Rochelle's blood is on Toby Madden's green vest. Rochelle's blood is on Toby Madden's gray shirt. Rochelle's blood is in that bathroom sink. And Rochelle's DNA is down in the well of that Swiss Army knife. Down in a part where, as she said, you're not going to stick your finger down in there. It's not going to fit. And we know from Dr. Updegrove that Rochelle died from 55 stab wounds. They were on her arms, they were on her leg, they were on her torso, they were on her head, and one in the back. And he told you that there were defensive wounds on her hands and her arms, the bruising on her hands. He also told you there was a small knife that was used. And he told you that when you look at those pictures, the darker wounds are because the blood was still pumping. Her heart was still pumping. And those lighter wounds, they came as the life was slipping away out of her. You put these pieces together, and I submit to you that this is what you get. You got 3 City of Hamilton utility workers that leave that house and everything is fine. Something happens at this point, a piece we don't have, because the only 2 in that house are the defendant and Rochelle. Maybe she says something to him about the furnace. We don't know. But he goes off. And ladies and gentlemen, there's 1 stab wound in the back. And I submit to you that that's the first one. He attacks her from behind. He stabs her in the back with a Swiss Army knife. She turns, and she tries to defend herself. And this is where the defensive wounds come in. And he keeps stabbing her over and over and over 55 times. And in this process, they're knocking over the furniture. She's trying to get away from him. She's trying to live. She's trying to survive. But she doesn't. And then he changes his clothes. He throws that vest and that gray shirt in a completely dark basement, hoping that no one will find it. He ditches those white shorts and those KD8 shoes. Don't know where. Can't find them. He had 2 hours to do it. Then he tries to clean up. He's putting that rubbing alcohol everywhere in that front room. Detective Lucky told you, distinct smell. Then he goes in the bathroom and tries to clean himself up. That blood's everywhere in the sink. Her blood that he's washing off of him, washing off of his own hands, washing off of his own arms. Then he tries to clean up that knife. He tries to get her blood off of that knife. And then after he does all of that, he has the audacity to start giving her CPR when the police arrive and try to blame it on 3 City of Hamilton utility workers. And the final piece of that puzzle is what the defendant gave you here on Monday morning that I've already told you. I'm responsible for what happened to her. He said it to his daughter, sitting in the back of the courtroom. Ladies and gentlemen, you're going to have 4 counts here to consider when you go back to deliberate. And the judge is going to instruct you on the law and what some of the terms are in those counts and what they're defined as. And I'm going to give you a shorter version of that here now. Can you turn it? Thank you. Take these in reverse order. So I'm going to start with count 4 because I think it's a more logical way to look at these. Oh gosh, how do I? I'm sorry. Do it one second. I think I got it. Count 4, felonious assault. Knowingly cause or attempt to cause physical harm to Rochelle Broussard by means of a deadly weapon, in this case a knife, and then it occurred on October 11th, 2022 in the city of Hamilton, Butler County, Ohio. The judge is going to instruct you that knowingly means a person acts knowingly regardless of their purpose when the person is aware that their conduct will probably cause a certain result or probably be of a certain nature. When you stab somebody 55 times, it's pretty clear that that conduct is probably going to have a certain result or be of a certain nature. I don't think there's any disputing that. And in this case, he used a knife. I submit to you, it's that Swiss Army knife. And clearly, as we've stated over and over, and you've heard, this happened on October 11th, 2022 at 1270 Parish, the city of Hamilton, Butler County, Ohio. Count 3, felonious assault again, serious physical harm. I just read to you before what knowingly means. It's the same argument. Cause serious physical harm to Rochelle Broussard. Ladies and gentlemen, there is nothing more serious than death. That is the worst kind of serious physical harm. And again, October 11th, 2022. Count 2, murder. Caused the death of Rochelle Broussard as a proximate result of committing the offense of felonious assault. We just went through those felonious assault counts. 55 stabs. She's killed. She's laying dead in that floor in the front room of 1270 Parish. Count 1, murder. Purposely caused the death of Rochelle Broussard, again on October 11th of 2022. The judge is going to tell you that a person acts purposely when it's his specific intention to cause a certain result. Ladies and gentlemen, there is no other result that can be intended from stabbing someone 55 times. There's no mistaking that. Clearly it killed her. It hit her internal organs. It hit her liver. Pierced her heart. Pierced her lungs. That's a certain result. You know what you're doing. So you've sat here a week and listened to all of this. You've received all the pieces of that puzzle. Put them together. It's very clear. That puzzle is the defendant, Toby Madden. Find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder?
Thank you. The first thing I want to do is thank you. We've taken 5 days away from you. Some of you may be happy that you're away from work, but we've taken you away for 5 days to consider this case. And as we can all agree, couldn't get much more serious with allegations than what we've been here all week for. Don't think that it doesn't go unnoticed that we don't see you paying attention, listening to the witnesses. Didn't appear that anyone fell asleep. We appreciate that you did that because a serious case involves serious jurors, and you're up to the task. Before I start with making my comments and arguments about the evidence, when you cause the death of someone, the state of Ohio has to determine, well, what's your level of culpability, meaning something, was it negligent, was it reckless, was it intentional, was it purpose? For example, you run a stop sign driving and you hit a pedestrian and they die. Something like that could be negligent. You're coming here to court today, you're going down the interstate 110 miles an hour, and you hit a car and somebody dies. Well, you didn't mean for that to happen, but you were certainly probably reckless. You also may have a situation where you get in a car, you see somebody, and you tell yourself, I'm going to hit that person. I'm going to run them over. Then you start to get into an intentional, purposeful act. And then the top of the top, which is not here, but you decide, I know when, where somebody's going to be, I'm going to hunt them down, and I want them to die. And that gets into something much more higher than what we're here today for. My point with this is you can't just focus on the fact that someone is dead. You have to look at their level of culpability, because this level of culpability is in these elements. The judge will give you the instructions on this to make that determination. Toby and Rochelle, They are together 28 years. Some of you jurors may not even be 28 years old, or just a little over than that. That's how long they were together. They're together Michaela's entire life. They're both grandparents together. Their relationship, you heard from witnesses, it's up, it's down, it's hot, it's cold, it's rocky. We even heard about some physical confrontations. Not every relationship is perfect, and certainly this one was not either. You also heard evidence that Toby believed that Rochelle was cheating on him. You also know that Rochelle is trying to renovate Parrish. We saw the pictures, you saw the materials, you heard from witnesses. She's trying to get what used to be apparently a drug house, people in and out. They're trying to get this together. They're trying to renovate it. And it's not something where she's doing it and she continually kicks Toby out. Toby's there almost every day. You heard evidence, you heard testimony that Toby may be involved on some level with helping this. He's there when she's trying to get the gas fixed. So I submit to you that they're both renovating this Parrish Avenue. Maybe to start a different life, the new turn in the relationship, the hot and the cold, maybe now we're hitting our stride, we're back to good. Let's go to Parrish and get this thing together and turn a corner. The neighbors are happy to see them. I know Miss Myers, the bank robber, she comes in, she's Toby's strange, he's a little weird, but he's over there every day. She lets him come into her house, use her phone. She's thrilled to have Rochelle and Toby there because she told you what kind of people were coming in and out of that house. Finally, she has good neighbors. And when she says neighbors, she's referring to Toby and Rochelle. Back to the culpability. All right, so Toby is charged with two different types of murder. In Ohio, there's two different statutes. The first statute that you can be charged with murder is under Section A. In order to prove that, the state has to prove beyond a reasonable doubt that Mr. Madden purposefully did this. More specifically, that Toby's specific intention was to cause the death of Rochelle. That this is what he wanted. That was his specific intention. Rochelle needs to die. The second way to prove murder in Ohio, the state is charging him in a knowingly manner. It's called felony murder. And as a result of that, you have to prove the culpability. We call it the mens rea, what someone's thinking. They have to prove that he knowingly wanted it to happen. For knowingly, state has to prove beyond a reasonable doubt that Toby was aware of his conduct will probably cause a certain result or will probably be of a certain nature. That he knows what he's doing. That she needs to die. I want her to die. I'm going to do this so she's dead. Part of count 2 involves a deadly weapon. We're going to get back to that in a second. But these, I'm assuming the Swiss Army knife, the 2-3-inch tiny Swiss Army knife, I'm assuming that's what they're alleging as the murder weapon, the one with no blood on it. We'll come back to that. So, we have these two things. We have purpose, and we have knowing. Let's think about the evidence here. You didn't hear from Toby, but the state decided to not only play, but talk about what he said here in open court. Nothing could make an attorney more nervous than when a client starts to talk, right? This is what Mr. Madden said. This is the state has put this into evidence. I'm responsible for what happened to her. I didn't mean to do it. I'm so sorry. I love you. I don't want you to hate me. I don't think any witness, law enforcement, neighbor, whoever, didn't deny. Also, Toby was hysterical. He's distraught. He's crying. He can't keep it together. The detective said he was down there for 4 or 5 hours. And he didn't see the video, but he did agree with me. Mr. Madden spends almost all that time just laying on the floor. Hysterical. He's given CPR to Rochelle. State even wants you to think that he's given her CPR after she's even dead. Is it someone who purposely wants someone dead? Why would you even give CPR at the beginning if you've done it? And why would you continue? If she's dead, that's what you want. You leave them alone. You walk out. You get Rochelle's car out front and leave. You walk away. You run from the police. You don't sit there and continue to give CPR to someone who's dead if that's what you want. What's the point? We're going to get to that. What about the gas service guys? Hey, we come in 8, 9 o'clock, whatever time. Rochelle's got the big dog. We're there to do a job. Nothing seems unusual to us. Rochelle doesn't seem worried, upset, afraid. Heck, it sounds like Toby's asleep in the chair. No worry in the world. Is right there in the chair, maybe woke up and said, "What's up?" We don't hear from them gas workers there's any tension. I mean, I know they're not there to be Dr. Phil or somebody like that, but think about it. If you're a serviceman going in and out of people's houses, you see something wrong, you may walk out and think, something weird about that. You know, I'm here to do the gas, but in your mind, you would remember that. Because they certainly remember the dog, right? The big dog. 2 years, and they still remember that. If they just saw something unusual, they would have told us. Here's my point with that. Got Toby asleep, everything calm. Then, 2, 3 hours later, if the state would please pull up 39. Just so you know, only one computer's connected, so that's sometimes we. 2, 3 hours later, here's what we got. The gas guys went in there and said nothing wrong, didn't see anything wrong. She seemed fine. He was asleep. I didn't see anything on the floor. Police come in. Here's what they see. Also, please pull up 40. Then they see Rochelle there. Broken lamp. Furniture on the floor. What do they also find? Please pull up 64. Blood on the windowsill. 67, please. Blood splatter on the wall. So we go from gas workers saying, no problems, everything seemed fine. 2 hours later, we got this. So what happened? Well, what about motive? Why would he want her dead? The state doesn't have to prove motive. They'll get up here in a minute and probably tell you that. You'll be instructed that they don't have to prove motive. It's a good thing they don't have to prove it, because guess what? What is it? Where is it? What did we hear? Why would he want to stab her? I mean, these people are together this long, and if you believe Miss Cook's story, that Toby Madden continually said he was going to cut her head off and put her head in the lap of grandma, similar to something out of The Godfather. Well, if you do, I'll just say whatever. Why is that happening? Where's his motive to want to do that? Everything is fine, not even 2 hours before. They're working together on this house, 28 years together. They got grandkids. And remember, we go back to the mental culpability. It's not that she's dead. It's not that her death is caused. It's the mindset. Right? Because in this scenario where I run a stop sign and I run someone over and kill them, that's a homicide. Someone's dead. And then when I get in my car and I go, I know where you're going to be. You're going to be at Starbucks at 9 o'clock. I'm going to hunt you down, find you, run you over. Those are both homicides. Those are both scenarios where someone is dead. I've caused the death in both of those. The problem for the state is that you've charged him with the highest level, that this is what he wanted, that Toby Madden wanted her dead. If he's continually, again, if you believe Miss Cook, that he walks around saying, I'm going to cut her head off, put it in mom's lap, wouldn't something have happened before 28 years? I mean, why that day? Because something happened in those few hours after those gas workers left. Something quick happened. There had to be an argument, something, because all that furniture's on the ground. Now, I am not bringing up Toby's injuries that we're going to see here in any way to try to say that he's the victim. I'm not. If the state would please pull up 82. I am in no way trying to compare and contrast some of these, what appear to be maybe minor injuries on Toby that the police took. I am not trying to do that in any way. It is terrible what happened to her. But does this tell us a story about something that may have happened? Because the state wants you to believe Toby, after 28 years renovating, we're grandparents together, October 11th is the day Rochelle needs to die. Something happened. Furniture, Toby's injuries, while minor, something's going on. We know he thinks she's cheating. Right? People told us that. His own daughter told us that. He thought she was cheating. It's hard to imagine that October 11th was the day that Toby just decided Rochelle needs to be done. And I know I've harped on it twice, and I'll harp on it a third time, because don't just look at the fact that there was a death caused. You have to look at the mental element. Because the state has to prove beyond a reasonable doubt every element. They have to prove that her death was caused. Absolutely. They also have to prove his mindset. Did he act with purpose? Did he know what he was doing was going to cause her death? If the state could please pull up 149. I believe that the state's claiming that this is the murder weapon. I didn't see, I mean, there was another knife, but it wasn't even analyzed. I mean, Toby, you didn't hear any evidence that he left or anybody else coming in or out, so this is the knife they got. And if this is the, first of all, I submit to you, this is not a deadly weapon, because I don't know if it could inflict the injuries that some of those are. You had officers there for over 9 hours, and they went there for 2 days. And this is it. This is the deadly weapon. But it doesn't have any blood on it. It was sent for analysis. Nothing there. I mean, if you're going to stab someone 55 times to the point where intestines are coming out, and it's deep enough to touch the heart. I know I started with the liver, and then the coroner said, well, you can get to the liver like this. But then he said something like the heart. It's a little different. State has to prove to you that he used a deadly weapon. This is what you've been provided. I submit to you that that wasn't even used because there's no evidence that it was. Or DNA or what is the DNA expert talked about something being down inside this Swiss Army knife, but it wasn't blood. 55 times, intestines out, and there ain't any blood on that? You got one detective who said, I went in, it was so unbearable, the smell of alcohol. Next officer said, no, I didn't smell anything at all. Did you hear any testimony that, hey, we went and got Toby from the scene, we were interviewing him, and he smelled of alcohol? Rubbing alcohol, not like liquor, booze. Who else told you that? Nobody. If you're cleaning up the crime scene, as they've claimed, where is all the evidence of this alcohol and stuff? It's not there. And you know what that also does? It proves that he didn't purposely do this, that it wasn't his specific intention. He didn't know that's the result. People who clean up crime scenes, people who leave them, do that stuff. Those are the people who want something done, and they're going to take care of it after. People who want others dead don't stick around to give CPR, and don't give it to the point where someone is dead. Ladies and gentlemen, the state of Ohio can't meet these elements. You have to stay focused on the mental element of this. She's dead. It's horrific. It should not have happened, but it did. The element you need to focus on is the mental part of this, because they want to prove to you, and they have to prove to you, that this is what he wanted. And that's simply not the case. Thank you.
Thank you, Mr. Wilder. State rebuttal.
Yes, Your Honor, thank you. May it please this honorable court. Good morning, ladies and gentlemen. 55 stabbings. 55 stabbings. To the head, the arms, the hands, the chest, abdomen, liver, lungs, heart. 55 stab wounds. Ladies and gentlemen, this is personal. This is personal. And again, we heard there was some cross-examination about, wasn't there a break-in, 5 days prior? This isn't some drug coming in and doing this. This is a personal attack that happened. 55 stab wounds. Nobody else came in and did this. It was this defendant right there. the city workers, they had nothing to do with this. It was this defendant. And I submit to you, ladies and gentlemen, this defendant committed purposeful conduct and knowing conduct. And why is that? What do we learn from Catherine Daly from BCI? She told you that this defendant's clothing, the vest that we saw him wearing at Kroger, the gray shirt we saw him wearing at Kroger. What did that have on it? It had Rochelle's blood from those 55 stab wounds. Her blood is on his clothing. And what did he do with it? He hid it. He put it in the basement, in the dark basement. This isn't some accident or anything like that. If he didn't mean to do something, why is he covering it up? Why is he trying to hide his clothing? Where are the shorts? 55 stab wounds. What else does this defendant do? There's nobody else that's in this house. Nobody's coming in. Nobody's getting past Rochelle. Nobody's getting past the dog, putting his clothing on, stabbing her, and then cleaning up afterwards and hiding the clothing. That's not happening. It's this defendant's conduct. What else does this defendant do? He cleans up in the bathroom. Her blood is in the bathroom sink. If you didn't mean to do something, why are you hiding your clothing? Why are you cleaning up afterwards to make it look like it didn't happen there? Why do that? It is purposeful conduct when you stab somebody 55 times. The head, the chest, the arms, the hands. What's the phrase, death by 1,000 cuts? This defendant sure tried. 55 is a lot, ladies and gentlemen. And Rochelle's screams were so loud. The 74-year-old bank robber that was next door on her front porch heard Rochelle screaming for her life. Obviously, you guys are the fact finders and truth seekers. You heard her testimony from this witness stand. Is it reasonable to believe that that blood-curdling scream that she heard is coming from Michaela's mother? Your reason and common sense tells you that, ladies and gentlemen. This isn't some accidental conduct by this defendant. He wanted Rochelle to die. What else did this defendant do? In his clothing, the gray vest, the gray shirt, washed up the blood. And again, the 12 of you are the fact finders and truth seekers in this case. And I'm not going to put any photos up here on the screen, but look at those stab wounds to Rochelle. Look at the cutting in the clothing of not only Rochelle, but of this defendant. Doesn't it kind of look like that knife that we just had up there, that Swiss Army knife? Doesn't it kind of look like that knife? And where did we find that knife? It wasn't laying there in the middle of the crime scene. We put it in Rochelle's purse, her book bag. If this was some accidental conduct or he didn't mean to do something, why go through all these measures, these methods, to try and hide what it is that happened, to hide the clothing, to wash up the blood, to hide the murder weapon? Why take the time to take the bloody clothing downstairs in the dark? Why? He wanted Rochelle to die on October 11th. Whatever it is that happened, was it something over, I think it was Brian Short, I believe you heard from him on Tuesday morning. He told you, I'm explaining to Rochelle what it is that's going on, what it is that happened, why we couldn't work on the gas lines. And Brian Short, from this witness stand right here, he told you, as I'm explaining this to Rochelle, he was looking right at this defendant right here, giving him the look. And you're right, Mr. Wilder is correct. I'm going to tell you, I don't have to prove what the motive is in this case. The 55 stab wound is pretty darn personal. Something happened. "55 stab wounds. How do you not mean to do it when you have 55 stab wounds? One stab wound, maybe you could say you didn't mean to do it. Probably not, but again, maybe. But 55 to the head, the chest, the abdomen, the arms, the hands. Come on, ladies and gentlemen. That is not reasonable. It's not reasonable at all. Why give CPR? Why give chest compressions? Again, defendant is keeping up the ruse of trying to get people to believe that he's not the one to do it. Hiding the clothing, washing up the blood, putting the murder weapon back in her purse. Detective Katie Johnson told you when I get there, this woman's obviously dead. The intestines are hanging out of her body. She's pale. He's trying to keep up the ruse that he had nothing to do with this. Defendant told you from his mouth. State's Exhibit 250. You'll have a chance to put it back in the jury room. He told his own daughter, the daughter that him and Rochelle have together. This defendant said, "I'm responsible for what happened to her. I'm responsible for what happened to her." What happened to her was 55 stab wounds. And that's what he's responsible for, ladies and gentlemen. Ladies and gentlemen, I do want to thank each and every one of you for your time and attention as well. Some of the same things that he said. I've been paying attention to each and every one of you. As you're seated over there, you've been paying attention, you've been taking notes, you've been listening to the testimony. Thank you for your patience with me through some of my computer issues that I had. 55 times. Each time this defendant stabbed Rochelle, she got closer to her death. As Dr. Updergrove told you through those photographs. Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State Exhibit
Jurors, I'm
number
going to ask you to
66
return to the jury
State
room.
Exhibit 66 is a stick in there. And I also, if you look at the video, some questioning me down at the police station. If you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Recess at this time.
Look at State number Exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get that. Okay, now we're
Right.
done. Okay, so
I know you're not commenting.
the court is not going to tolerate. Let me get back on from there.
You're not, listen,
All right,
what
we're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the
sit
upstairs
here
remote
and
location and
allow
take a
you
recess.
to.
Thank you.
This is what you did the last time went on. You wanna come running down the hall this time? You got something to say?
Mr.
Okay, it's going to take us about 10 minutes to get situated for the defendant to appear remotely. I do have copies of the final instructions for counsel. We'll share those at this time. And the court will need to read an instruction to the jury why he is not in the room. I'm going to take that straight out of the Ohio Jury Instructions Manual. And, once we are ready to go upstairs, we will proceed. But if counsel wants to review that instruction, you're welcome to do so. It's 2 OJI CR 4303, and if there are is any discussion you'd like to have about that prior to me giving you that, you're welcome to let me know. Okay, so we can go off the record. Thank you.
Thank you, Judge.
Is that the copy?
Yes.